This is one of the most exciting of the speaker programs of the entire year, every year, where faculty gives you a preview of what the Supreme Court may or may not do this year. I will just make two very short comments before introducing the panelists. Earlier, sometime within the past couple of weeks, Justice Ruth Bader Ginsburg was speaking at a law school, and she was asked what the Supreme Court term was likely to be like this year, and she said, the only thing I'm going to say is that it's likely to be momentous. So there's a lot of big cases, and then, of course, there's clearly one other significant development that changes the court this year, which is that there are now, from the start, 9 justices, with Justice Gorsuch having replaced Justice Scalia. So and that'll affect some of the cases, I think, without any doubt. So today we have 3 of our finest professors here to talk about the court, and all of them have a great deal of experience with appellate law, having all been clerks for appellate courts. On my right is Jennifer Chacón, who I'm sure most of you know, who clerked in the Ninth Circuit Court of Appeals after finishing law school and teaches immigration law, constitutional law, other subjects. Rick Hasen on the far left, seating-wise, after finishing law school and getting his PhD, clerked on the Ninth Circuit Court of Appeals also. And sitting to my immediate left is Professor Leah Litman, who also teaches constitutional law. She clerked on the Sixth Circuit Court of Appeals and then on the United States Supreme Court. Each of them is going to talk for about 10 minutes, and then we'll have questions. And Professor Litman, why don't you get us started?
All right, so I am going to try to squeeze in 4 cases to this 10-minute period. So I'm not going to go into a ton of depth about any of the cases, but just provide an overview of them, and I'm happy to talk more about any of them during the Q&A. So one of the cases that the court is going to hear this term is Carpenter versus United States, which is a criminal procedure case that raises the question of whether individuals have a reasonable expectation of privacy in cell site location data. So the way cell phones work is your cell phone transmits your location information to cell sites, and that information then your cell phone provider has. Because you are technically giving that information to a third party, namely your cell phone provider, the government argues you are disclosing that information to a third party, and thus you have no reasonable expectation of privacy in that information, and they can obtain it without a search warrant. Obviously, knowing where you are at all times is very convenient for the government if they are investigating a crime. So the question in Carpenter is whether the government has to obtain a warrant to obtain your cell phone location data. And the government's argument relies on this third-party search doctrine, the idea, again, that if you give information to a third party, you have no reasonable expectation of privacy in it. So the government is essentially arguing that giving your cell site location data to your provider is like inviting someone into your home or disclosing to someone that you've committed a crime, which is kind of a bonkers argument given that not a ton of people know that they are telling their cell phone provider where they are at all times, and you also don't really have a choice about whether to do that given the need to have phones in modern society, and that's just how phones work. So that's Carpenter. Another case the court is going to hear is Jesner, which raises the question of whether corporations can be sued under the Alien Tort Statute, which is a statute that allows individuals to recover for human rights violations in federal courts. This question, the court originally granted cert on to decide whether corporations could be sued under the Alien Tort Statute in 2011 when I was clerking at the court. So going over Jesner has brought me a little PTSD. But the court didn't ultimately decide in Kiobel whether corporations could be sued under the Alien Tort Statute. They instead adopted a rule about extraterritoriality, namely whether violations of the Alien Tort Statute that happened outside of the United States to entities not from the United States that didn't relate to the United States could be form the basis of an Alien Tort Statute. So question in Jesner is whether corporations can be sued under the ATS. The question largely turns on how you interpret a super ambiguous footnote in Justice Souter's opinion in Sosa versus Alvarez-Machaim. So we will get the answer to that question by the end of the term, and that is the question in Jesner. The other case I wanted to talk about requires a bit more explication because it's a case about a complicated arrangement of military commissions that relates to the body that hears cases from Guantanamo Bay. And that series of cases is a group of 3, Cox, Dalmazzi, and Ortiz. These cases relate to the structure of the commission for the CMCR. Briefly, the way this statute and the proceedings work is there are a group of military judges who can be assigned by the secretaries of their respective divisions to serve on both the Court of Criminal Appeals within their respective divisions and also on the CMCR. When military judges serve on the Court of Criminal Appeals, they are supervised by other executive officers and subject to appellate review by other executive officers on the Court of Appeals for the Armed Forces. When they serve on the CMCR, however, their decisions are only reviewable by the Court of Appeals for the DC Circuit, which is staffed by federal judges. So military judges who are appointed to the CMCR were originally not put through presidential appointment and Senate confirmation. They were instead just appointed by the secretaries of their respective divisions. That appointments problem immediately raised questions about whether their appointments violated the Appointments Clause of the Constitution, which requires the president to have the ability to appoint principal officers whose decisions aren't reviewable by other executive officers. Seeing the constitutional problem, the president immediately took steps to essentially submit their nominations to the Senate. The Senate automatically confirmed them, and they thought that would be the end of the matter. However, there's a super old Civil War era statute that prohibits active military officers from holding civil offices. So one question these cases raise is whether the service of these military judges on the CMCR violates that statute, whether their appointment is inconsistent with the Appointments Clause, whether the restrictions on the president's ability to remove them is a violation of Article 2, and a host of other complicated statutory and constitutional questions. The cases are really significant because the CMCR hears, again, all of the military commissions cases arising out of Guantanamo Bay. So if the CMCR is improperly constituted, either under the Constitution or statute, then there are difficult questions about what to do with the slew of Guantanamo cases that they have been and are still adjudicating, whether to basically void those decisions, whether writs of mandamus should issue, and a bunch of remedial questions there. But the CMCR also hears cases arising from ordinary military discipline, and Cox, Ortiz, and Dalmazzi all involve military officers who were found guilty of various small petty crimes like minor drug offenses and whatnot. So the question in these cases is whether the service of these military judges on the CMCR violates the Civil War era statute, which prohibits military judges from serving in civil offices, and the Appointments Clause, as well as Article 2. The case that the Supreme Court is no longer going to hear, but perhaps was one of the more anticipated ones from this term, the case about the legality of the president's entry ban. So I'm sure you all are familiar with this, but back in January, then again in March, the president signed executive orders suspending the entry of foreign nationals from several Muslim-majority countries from the United States, and also suspended the refugee program for 120 days, again from several Muslim-majority countries. Immediately, those orders were challenged on statutory and constitutional grounds. The Court of Appeals from the Fourth Circuit and the Court of Appeals for the Ninth Circuit both found the order unlawful, though for different reasons, and the government petitioned for and obtained certiorari in the Supreme Court. However, at the end of September, the entry ban expired. The entry ban only lasted for 90 days. The refugee suspension will end in another, I believe it is now 18 days. The refugee suspension will end. On top of that, the president has just instituted an entirely new set of restrictions on entry and the refugee program. So the Supreme Court was originally going to hear that case next week. However, immediately after the entry ban expired, the Supreme Court removed the case from its calendar, ordered the parties to brief the Supreme Court on whether the case had become moot, i.e. whether the Supreme Court could hear the merits at all. And if it had become moot, which, spoiler alert, it has, whether the Supreme Court should allow the Court of Appeals decisions to stand and leave them in place, or whether it should vacate the underlying decisions and essentially wipe them off the books. So the parties are going to be submitting their briefs on that question on the 5th, but I think that the general consensus is the Supreme Court is not going to decide whether the entry ban and suspension of the refugee program were lawful because those programs have expired. The only question is what the Supreme Court is going to do with the underlying decisions that found the entry ban and suspension of the refugee program unlawful. There's a very technical federal courts doctrine called Munsingware that says if a case has become moot before the Supreme Court has had the opportunity to review it, the general rule is the Supreme Court vacates, i.e. does away with the underlying decision. So that is the presumption of what happens when a case becomes moot. The question is whether that presumption applies to the entry ban cases.
Great. Who's next? All right, Rick.
I don't know that I'll be as efficient as Leah, but it's great to be here. And so when Justice Ginsburg said momentous, she meant terrible, at least from her perspective, although there are some signs that, with Justice Kennedy still on the court and still the swing voter, there are some signs that things won't necessarily all be terrible from her perspective. But I should point out that it's not only that there were a few cases, including one that Dean Chacon's going to talk about, that where the court had to set it over for re-argument because presumably they were divided 4-4. I think you're talking about one of those.
Yeah.
It's also that the court decided some cases in ways that avoided issues. And in one of the cases I'm going to talk about, they've taken a new case that raised an issue that was an old case. I'm going to talk about 4 cases quickly, 2 election cases and 2 labor law cases. I have the advantage that 2 of the 4 cases were already argued. The term started first Monday in October, so first 2 days they've heard 2 of these cases. So the first case, and I think the most important one from the election law, the 2 election law cases, is a case called Gill v. Whitford. It's a case involving partisan gerrymandering. If you don't know what that term means, it means how district lines are drawn. For a long time, the Supreme Court has said that you have to draw districts with equal or mostly equal populations in them. But even given that constraint, and even given other constraints like the Voting Rights Act, it's possible to draw district lines so that it helps one political party or the other. And so in Wisconsin, where the Gill case comes from, the Republican legislature drew the lines, and they drew them in a way that even though a majority of voters have consistently been voting for Democrats for the state legislature, the Republicans hold a majority of the seats. And the question is whether or not that violates the Constitution, one or another part of the Constitution. I'll get to that in a second. But so the history is, in 1986, the Supreme Court decided a case called Bandemer, where they said, yeah, we can hear these cases, and here's the standard. And from 1986 to 2004, they never found a partisan gerrymander ever. So the standard was one that no plaintiff could ever meet. 2004, the court revisited the issue, and the court divided 4-1-4, which is meant to tear out a law student's hair. 4 justices, led by Justice Scalia, said these cases are non-justiciable. There's no manageable standard to know when taking party into account is too much. 4 justices, of the 4 liberal justices, offered a variety of different standards to police this: bad intent, bad effect, burden shifting. They came up with all different kinds of things. And Justice Kennedy stood in the middle. Justice Kennedy said, I agree with the liberals that these cases are justiciable, they could be heard. I agree with the conservatives that every standard that's been proposed so far is a bad standard. It's not a manageable standard. So keep trying. So you lose, but the courthouse door is open. And maybe we should look at the First Amendment rather than the Equal Protection Clause and people's freedom of association as the basis for this. Maybe we should look at history. Maybe we should look at computers. And so for the last 13 years, plaintiffs have been trying. And they finally found a way to get a case to the Supreme Court through the court's mandatory jurisdiction from a 3-judge court. The lower court found that there was a standard and that Wisconsin violated that standard. And so the Supreme Court basically had to take the case because otherwise A Supreme Court affirmance without a decision would have meant that the lower court was right, but no one would know what the reason was. And so the court basically had to take the case. The argument was earlier this week, and everyone was watching Justice Kennedy. The liberals felt exactly what you'd expect. This is terrible, this is horrible. The conservatives felt exactly what you'd expect. Justice Gorsuch said, what was the line, Leah?
Let me bring you back to an arcane little matter called the Constitution.
So Justice Gorsuch, in his humble way, was expressing some skepticism about the theory. But Justice Kennedy, most interestingly, didn't ask any questions to the side that was arguing that there was a good standard. He asked only questions to those defending the law. And the otherwise excellent Erin Murphy, who argued the case for the state legislature, when she was asked what the benefit is of partisan gerrymandering to the democratic process, had an answer that was literally unintelligible. I mean, I don't know what it means. I haven't highlighted it on my blog because it's not nice, but they're really so there's a chance that Justice Kennedy's going to go along with the liberals, but there's also a chance that the court's going to say there's no standing here and put it off. Justice Kennedy is rumored to be thinking about retiring as soon as the end of this term, and so this is the last chance. This is the farewell tour. This is the chance to say something. So we'll see. The other election case, which I'll talk about much more briefly, is called Husted versus Philip Randolph Institute. It involves the procedures for removing voters from the rolls who don't vote. There are a couple of congressional statutes, including a 1993 law called the National Voter Registration Act, or the Motor Voter Law, and the Help America Vote Act of 2002, which have rules for when people register to vote in federal elections, when they can be removed from the voting rolls. And they basically say if you've died or you've changed your address, you can be removed from the rolls. But you cannot be removed from the rolls for, quote, a failure to vote. So Ohio has a procedure where if you don't vote in one federal election, they send you a piece of mail that says, do you still want to vote? And if you don't answer that and you don't vote in 2 more elections, you're kicked off the rolls. And the question is, are you being kicked off the rolls for your failure to vote, or are you being kicked off the rolls because presumably you've moved because you haven't responded to the mail? And so it creates a statutory interpretation question and actually a proximate cause question for my former tort students in here as to whether or not it's the failure to vote that is the cause of your removal, or something more than the failure to vote that is the cause of your removal. If Ohio wins, and there's reason to believe Ohio will win since there was no circuit split when the court took the case, more states, more Republican states are going to more easily purge voters from the rolls. This is seen as a partisan issue, as is the gerrymandering case, just because Republicans control more districts, more state legislatures, and therefore more redistricting. So there's a lot of partisan overtones to both of those cases. All right, on to the 2 labor law cases. The first case is a case called Murphy Oil, which has been consolidated with 2 other cases, a case called Epic and a case called Ernst & Young. It's a clash between 2 laws, or 2 sets of laws. Here's where the conflict arises. You're an employee, not a union employee. You go to work for IBM or whoever, or Ernst & Young, and as part of your employment agreement, you say, I agree that I will arbitrate any employment disputes. And they make you sign that. If you want the job, you sign that. And you also promise in that, and I won't bring any class actions in arbitration, I'll just do it alone. So the National Labor Relations Act and a related law basically say workers are protected for concerted action. You can be able to work in concert, and you can't have laws that prevent workers from banding together for concerted action. But then there's the Federal Arbitration Act, which basically says there's a huge thumb on the scale in favor of arbitration, and other laws have to give way. And so this is a clash between the Federal Arbitration Act, where the Supreme Court, again a conservative-liberal split, Supreme Court has been upholding all kinds of pro-arbitration rules, taking cases out of court, anti-class action rules, and the labor law, which says that people should be able to band together. That case was argued this week. I don't think it looks good for the workers from having read the transcript of that case. And then the final case, and this is the more important of the labor law cases, is a case called Janus, J-A-N-U-S. This is a case involving public sector unions. This same issue was before the Supreme Court in a case called Friedreichs, and it had been before the court before. The question is this. Suppose that you are in a public, you're working as a public employee, and you basically are forced, if you're a public employee in a state where there are unions for public employees, you don't have to pay the union dues that go towards political activities of the union. You have a First Amendment right not to, the Supreme Court said a long time ago. But you have to pay the agency fees, the fees that the union uses for its negotiating to solve the collective action problem. You have to pay these fees. There's an argument that this violates the First Amendment rights of people who don't like unions. Justice Scalia was on the side of saying, no, there's not a First Amendment issue. When the Friedreichs case was argued while he was still alive, it was, well, you know, I may have changed my mind. Justice Scalia died, the court split 4-4, case was affirmed by an equally divided vote. Now the issues come back in a new case. Every indication to believe that Justice Gorsuch will vote like Justice Scalia seemed like he was going to. We expect a 5-4 decision, which will have the effect of decimating public sector unions in lots of places.
And I am bringing up the rear here with 3 cases, 2 of which were also already argued. So we have the advantage of being able to sort of get a sense of where those are going. And then a final one, which is, I think, viewed as one of the blockbuster cases of the term, where I won't even speculate as to what's going to happen. It hasn't even been calendared for argument yet, so you can direct questions about that to others. So the first case that I wanted to talk about is Jennings versus Rodriguez, which is probably familiar to some of you if you came to the MOOC here a few days ago when Ahilan Arlananthan from the ACLU of Southern California was mooted for his argument in this case. And this case involves a class of individuals who are in removal proceedings. Removal is a term of art in immigration. It encompasses both people who are being subject to potential deportation and also individuals who are being excluded at the border, or technically at the border, although they may physically be here, they have not yet been admitted. So all of those people would be in removal proceedings. And so these provisions deal with people who are in removal proceedings, and it's specifically for those lovers of the Immigration and Nationality Act, sections 235B and 236A and C, which apply both to non-citizens who are arriving and in many cases claiming that they are seeking asylum and raise arguments that they are afraid to return to their home country. And it also, these provisions also capture certain lawful permanent residents, including longtime lawful permanent residents who have been who've engaged in certain kinds of conduct that subject them to detention under these provisions. These detentions can be quite brief. The removal proceedings can be quite brief, in which case the detention is brief, but they can also be extremely protracted. So in this case, there are many people in Southern California who have clients who have been detained for years under these provisions pending removal proceedings. And these detentions happen without any individualized determination of whether detention is justified. So there is no bond hearing, or there is no moment where the individual gets to get up and say, I'm not a flight risk, I'm not a danger, I'll stick around, I'll show up for my hearing. That doesn't happen in these cases. They're just detained until the removal proceeding ends. And the Ninth Circuit found that this violated the statute. It said, we think the statute actually requires that there be a bond hearing in these cases with the possibility of relief if detention lasts for 6 months. So at the 6-month mark, you get a bond hearing, and if you're still detained 6 months later, you get another bond hearing. And the Supreme Court heard arguments in this case last term, and as Professor Hasen alluded to, they did not reach a decision in this case, which tends to suggest that they were about to split 4-4. They recounted it for argument this term, and it was just argued yesterday. When they asked for arguments again this term, they asked for a briefing to focus on the constitutional question, not on the statutory question. So not on whether the Immigration and Nationality Act in the statute requires the bond hearing, but whether it would be a constitutional violation not to have an individualized bond hearing for people who are in these situations of protracted detention. And there are 2 cases that are sort of helpful to thinking where the court might go on this. One is Zadvidis, which is a case from 2000, where the court was looking at people who had been ordered removed and were subject to detention under the statute. And in those cases, there were people who were sitting around for more than 6 months and for a very long time because they couldn't be removed, and they were just sitting in detention. And the court actually in that case read the statute to require a bond hearing after 6 months, which is sort of where the litigants in this case have drawn the assumption that a similar bond hearing is required in these sets of cases. But there's also a second case, DeMaio versus Kim, which was decided in the kind of post-September 11th climate when immigration detention was all the rage, and the court was highly deferential to what the administration wanted to do with immigration detention. And in those cases, the court decided that Congress could impose categorical mandatory detention, which meant you did not get an individualized bond hearing if you were in one of these buckets of mandatorily detained individuals. That might seem dispositive, but in that argument, the government said these detentions are really short. And the court sort of hooked onto that in deciding, Kim, and said these detentions are really short. They last about 47 days. And it highlighted it in their briefs, and it was actually part of the decision. So they alluded to the shortness of these detentions. It turns out that wasn't true. The government knew at the time that wasn't true. It was much longer, and it's much, much longer now. So part of what's at issue here is when those detentions really aren't short, when they're very, very long, doesn't this start to violate due process? Arguments were interesting. Justice Breyer actually got pretty exercised at some point and had to apologize for shouting, which was unusual.
Justice Breyer also got really worked up in Murphy oil.
Yeah, so I think he's feeling a little bit of rage. The argument primarily focused on the constitutional issue, so we're really trying to figure out, does due process require a bond hearing here? And the government, is, at its most extreme position, is saying, no, there is no due process rights, at least for some subset of some of these individuals. But the government, at other times, really does seem to concede that there is a due process right. In their briefs, the chief actually pointed out that their supplemental brief concedes that a delay in excess of 14 months could be unreasonable. So, and Justice Kennedy seemed receptive to this notion, although it's unclear where this is going, and seemed to be looking for some sort of standard of when would detention be too much and how would we know? So after all of that, I thought it was a little bit unclear where the court was going with this one. I'm feeling somewhat pessimistic, but less pessimistic than maybe I thought I was going to feel, so I'd welcome hearing from others. The second case is DeMaio versus Sessions, another immigration case, but this is a Johnson-related case, so I really feel like Professor Litman is the de facto owner of this issue. So I feel kind of bad talking about it. For me, this case is of interest not so much because of the Johnson issue, but because it's in a long line of cases where the Supreme Court is reviewing questions of whether particular kinds of criminal activity actually constitute removable offenses. And here's the background on this. In 1996, Congress enacted a law that hugely expanded the grounds on which you could be deported, hugely. So you now have a laundry list of offenses that can make you deportable. And one of these sections in this law was the expansion of the aggravated felony provision. So aggravated felonies are defined under INA section 101A43, for all of you lovers of the INA again. And the aggravated felony doesn't have to be aggravated, and it doesn't have to be a felony. So there are lots of crimes that fall into this aggravated felony category that really aren't that bad. And the government has taken a fairly aggressive position in a lot of these cases, arguing that all kinds of state statutes that encompass conduct that really don't seem that bad are aggravated felonies. And interestingly, they've been losing in the Supreme Court kind of again and again. And this case sort of tees up the issue in a way that's even kind of bigger. So DeMaio had been convicted under the California Penal Code section 549 for 459 for burglary, so California burglary. And the immigration court found this to be an aggravated felony. And an aggravated felony means mandatory deportation, no possibility of discretionary relief, no matter what the equities of your case, permanent bar on reentry. So aggravated felony, not good. So this was an aggravated felony under subsection F of the aggravated felony definition because it constituted, the government said, a crime of violence. And the crime of violence provision in the INA cross-references the U.S. Criminal Code's definition in 18 U.S.C. section 16B, which defines crime of violence to encompass any offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing a criminal offense. The problem for the government is that while DeMaio's case was on appeal, in Johnson, the court found that the Armed Career Criminal Act's definition of violent felony, which contained a parallel clause, was unconstitutionally vague. So in this case, DeMaio is saying if it was unconstitutionally vague for purposes of ACCA, it's unconstitutionally vague for purposes of the Immigration and Nationality Act too. The government is making several arguments here. They try to argue that it's not too vague. Needler says the court can comfortably look and see whether the statute has a core of administrable offenses, but then they started talking about the California burglary provision under which DeMaio was convicted, and it seemed not so clear that this wasn't vague. But then the government shifted gears and says there are also theories that this is just a different context. So for one thing, the reason we care about vagueness is because we care about notice in the criminal context. You have to be able to conform your conduct to the law, and you can't do that if a statute is vague. And we don't care about notice in immigration law. In fact, we've held that immigration law can be, deportation can be applied retroactively. The ex post facto clause doesn't apply to deportation provisions. So if that's the case, then maybe the the whole vagueness problem isn't really a problem. So that's one argument they're making. And the other is somewhat related but different, and that's that immigration really allows for broad deference to the executive branch. So Congress can craft a pretty expansive provision, and then we sort of leave it to the executive to decide who is appropriately removable under this provision. And that actually led to an interesting exchange in argument between Kneedler and Gorsuch. Kneedler says, Congress can choose to identify a category of crimes that it believed gave rise to a substantial risk. And we shouldn't expect the impossible from Congress when it wants to identify crimes by category. And Justice Gorsuch said, really? Even when it's going to put people in prison and deprive them of liberty and result in deportation, we shouldn't expect Congress to be able to specify those who are captured by the laws. So in that one brief shining moment, I thought he was actually sort of concerned that this provision may be unconstitutionally vague and that it might matter in the immigration context. So that's that argument. The final case is a case that hasn't been argued yet. This is Masterpiece Cake Shop. And I'm not going to say much about it, but it is one of the most watched cases of the term. This involves a Colorado anti-discrimination law that bars businesses that sell to the public from discriminating based on, among other things, sexual orientation. And in 2012, Charlie Craig and David Mullen went to Masterpiece Cake Shop in Denver, and they wanted to order a cake to celebrate their upcoming wedding. But Masterpiece's owner, Jack Phillips, says, I'm a Christian, I close my business on Sundays, I don't sell cakes with alcohol in them, and I refuse to design a custom cake that conflicts with my religious beliefs. So he believes that marriage should be limited to opposite-sex couples, and he told Craig and Mullins that he would not design a wedding cake for their wedding celebration. Craig and Mullins filed a claim with the Colorado Civil Rights Division, and the agency instituted proceedings against Phillips. Phillips responded he couldn't make the cake because of his sincerely held beliefs. The agency ruled that Phillips' refusal to provide the custom cake violated the anti-discrimination law and that he had no constitutional right to turn down their request. The Colorado Civil Rights Commission upheld that ruling, as did a Colorado court, and Phillips has asked the Supreme Court to take his case. This is being argued primarily as a free speech case. Phillips's brief stresses that the First Amendment protection is a protection of, he's stressing the First Amendment protection of expression. So he characterizes his cake as art that is conveying a message. And he says that anti-discrimination law, in this case, if it were interpreted to require him to provide the cake, would be compelling him to convey a message that violates his beliefs. And he says the First Amendment prohibits the state from forcing him to make the cake and precludes them from punishing him for failing to make the cake in this instance. So he says, this violates my First Amendment rights. It needs to be subject to strict scrutiny. There's no legitimate, let alone compelling interest that is at stake here. And this could be more narrowly tailored anyway because Craig and Mullen can get their cake in some other way. And so for all reasons, this is a case where there is a First Amendment violation. The state and Craig and Mullins contend there's no constitutional problem because the public accommodation laws target conduct, not speech. Phillips makes wedding cakes. Craig and Mullins want a wedding cake. He wouldn't sell them one. This violates the law. He could decline to sell wedding cakes generally, but having opted to sell wedding cakes, he has an obligation to sell wedding cakes to all comers. This isn't about art. This is about conduct. So he says they would say this isn't the same as his refusal to make a cake with alcohol, because he can make a big blanket decision not to sell wedding cakes because he doesn't like weddings. But what he can't do is, having made the decision to sell wedding cakes, decide not to sell them to people he doesn't like. The second argument here is a free exercise argument, that by requiring Phillips to provide a cake here, the government violates his right to exercise his religion. The state and Craig and Mullins argue in contrast that it is clearly established by the case law that the government can mandate compliance with a neutral and generally applicable law, including anti-discrimination laws. So if this is a neutral and generally applicable provision that applies to everybody, it would be applicable to him as well and wouldn't run afoul of the free exercise clause. This is not yet set for argument, as I said, so we can stay tuned on this one.